Hello and welcome to another segment of Good to Know Family Law. Today we're going to talk about child support, and specifically we're going to be talking about which parent has the burden of proof in a child support matter. We're also going to talk about whether or not the payer of support can deduct out business expenses that are related to depreciation of equipment. In this discussion, we're going to talk about a very important appellate court decision, and was possibly the most important decision in the year 2020. And it's also controversial, which I'll explain at the conclusion of this presentation. And I'm talking about in re Marriage of Hine. It's a case here in California that dealt specifically with a father's attempt to reduce his income by showing that he had business expenses that were depreciations shown on his tax returns. In this case, the mother earned about $9,000 per month as a physical therapist. She worked 3 days a week. Not bad money for working 3 days a week. The father, on the other hand, is a self-employed owner and manager of a farm and sole shareholder and president of 2 corporations. The assets of the father's corporation include 4 ranches totaling 110 acres. Picture that, 110 acres in California. He also manages more than 600 acres of trees and vines. So he's got some pretty expensive property that he's farming and probably renting out. He also owns other companies in real estate. Yet on his federal tax returns, the father claims that he earns only about $7,000 per month. $7,000 a month? I always wonder in cases like this, how do people go to court with a straight face making such statements? In February of 2014, the mother files a request for custody, child support, and attorney's fees. And the parties end up going to court. And one of the decisions that's very important in this hearing is how much support the father should have to pay the mother. While in court, the mother argues that the father was not being truthful with respect to the amount of money he earned on a monthly basis. She further argued that he was relying on his tax returns, and his tax returns would not accurately reflect what he has available to pay support. He was deducting out depreciations for equipment, and the mother argued that these depreciations are just phantom. They were not really changing his business, they're not reducing his income, and therefore the money that was deducted should be added back by the trial court to show what his real income is for calculating child support. Unfortunately, the trial court did not agree with the mother. It determined that it was appropriate to reduce from the father's gross income these depreciation deductions taken by the 2 corporations. The court stated that the federal tax returns are presumptively correct and it's going to follow the tax returns. Now, you may think that this is strange, but actually, this is how trial courts and family law practitioners have viewed tax returns based upon a decision entitled Marriage of Law. The trial court further stated that the mother had the burden of showing that these tax returns were incorrect and she had failed to do so. She offered no evidence to show that they were incorrect. Finally, the trial court rejected the mother's request for attorney's fees, and its rationale was that, look, father's tax return shows that he's earning only $7,000 per month. Mother's admitting she earns about $9,000 a month, and so the incomes are pretty close. It would be unfair to make the father pay attorney's fees based upon those facts. Well, the mother wasn't happy with the trial court and filed an appeal. And on appeal, she argued that the trial court erred by allowing the depreciation deductions to reduce the father's income. She also stated that the trial court erred by placing the burden of proof on her to show that his tax returns were incorrect. Well, fortunately for the mother, the Court of Appeal agreed with her, reversed the trial court's decision, and then remanded the matter back to the trial court to recalculate support based upon this decision. And in this decision, the Court of Appeal stated that there was no reason to depart from the treatment of depreciation deductions in relationship to child support, similar to the case of Asphalt, where the Court of Appeal stated that the deduction for depreciation of rental property was not appropriate. And similarly, in the case of Marriage of Rodriguez, where the deduction for depreciation of motor vehicles was not an expenditure required for the operation of a business. And in both of those decisions, the court stated that those deductions should be added back to support. And the Court of Appeal in this decision stated that there's no reason that the logic should be any different. The deductions have to be necessary for operating the business and should actually reduce the income. So in its holding, the Court of Appeal stated that the trial court erred in reducing the father's available income for child support by allowing these depreciation deductions taken on his income tax returns. The Court of Appeal was not saying that these tax returns were incorrect, but just because the IRS allows this doesn't mean that the family court will. Now, this is very, very important because, as I mentioned, for many years, family law practitioners, including judges and attorneys, have felt that marriage of law stood for the proposition that tax returns were presumptively correct and that the burden was on the receiver of support to show that they were not. The Court of Appeal held that the trial court erred in reducing the father's income for child support purposes by allowing depreciation deductions taken on his income tax returns. What's important here is to note that the appellate court was not saying that these tax returns were improper or that the IRS would not have allowed these type of deductions. The Court of Appeal was stating that in this case, the tax returns were not presumptively correct, and in fact, tax returns are not presumptively correct, contrary to what practitioners had believed before. In marriage of law, according to the Court of Appeal, was misread, and courts and attorneys were misapplying that decision. So this is very important because at this point, after this decision, when people come into court relying on their tax returns, they're going to have possibly the burden of proof to show that these deductions are correct. And in fact, in this case, the trial court erred, according to the Court of Appeal, by placing the burden of proof on the mother to show that the father's tax returns were incorrect. In deciding this, the Court of Appeal stated that the father had greater knowledge of the facts regarding his business, he had greater knowledge of his expenses, and he had complete control over his business financial records. It would be unfair, according to the Court of Appeal, to make the mother prove that these expenses were not valid deductions because she didn't have access to these records, and it would be much more difficult for her to come into possession of them. On these facts, the presumption that the father's tax returns were correct does not apply, according to this decision. Well, as I said at the very beginning of this presentation, this is an important case. It might be one of the most important decisions that was published in the year 2020. What we expect from this decision is that payers of support who are self-employed and who are relying on their tax returns now have the burden of proving that their deductions are related to their business and actually impact the amount of money that they make. Conversely, recipients of child support are likely to earn more child support when they file their motions and when the other party is self-employed. Now, this is a controversial decision. Payers of support aren't going to like this, and recipients of support are going to love this. As far as an attorney is concerned, it just depends on who you're representing. One last thing. This decision did not apply to spousal support. This was just a child support case. Many people think that the law that was addressed in this decision will only apply to child support cases, but others think that the logic is the same and that someday we'll see spousal support being treated the same way when it comes to people that are relying on their tax returns and the deductions regarding things like depreciation. Thank you very much for joining us on Good to Know Family Law. We'll see you next time. And be sure to join us on our social media sites if you want to follow and get more information that will be helpful to you in your family law matter.